Welcome, and thank you for viewing this Garden State CLE video. All Garden State CLE video programs can be seen for free 24 hours a day. Besides viewing the show, you can also earn CLE credits. In order to receive CLE credits for this program, you will have to do the following. First, download an evaluation form from the website. Just click on step number 3, and the form will appear on your screen. Please print out a copy. Next, as you watch the program, you will note that from time to time, a keyword will appear on the screen in red lettering. Write these words down on your evaluation form. Accurately recording these words is a required step in granting you CLE credits. Finally, at the conclusion of the show, simply complete the evaluation form and fax or mail it to Garden State CLE. Remember, viewing the CLE program is absolutely free. The only time you ever pay is when you want to receive CLE credits. You can pay for your CLE credits online or by sending in a check with your evaluation form. Now, sit back, relax, and enjoy the following Garden State CLE video from the comfort of your own home or office.
Garden State CLE. 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 Garden State CLE.
We've talked about the Fourth Amendment to the United States Constitution, all right, in very broad terms, which is fine. And I want you to all recognize that the state of New Jersey also has a search and seizure amendment in its own state constitution. Now, right now, we're operating under the state constitution of 1947, and in that constitution, specifically within Article 1, Paragraph 7, there is a search and seizure clause, and it is virtually identical to the language that's set forth in the Fourth Amendment to the United States Constitution, all right? And I don't think this is anything new. I believe the same language was incorporated in the 1844 Constitution of New Jersey as well. New Jersey has had 3 state constitutions in its history, one in 1776, one in 1844, and the most recent one in 1947. I'm almost positive that the same language in the 1947 Constitution was included in the 1844 Constitution, okay? So you say to yourself, okay, well, that sounds great. We have a state constitution that has language in it which is identical to the Fourth Amendment to the United States Constitution. What is the significance of that legally? And I have to tell you the significance is very difficult to, I'm trying to think of the right word here. Well, let me put it to you this way. You will find that as a result of these 2 versions of the Fourth Amendment, one in our state constitution and one in the federal constitution, that arrest, search, and seizure law is very, very different on a state level than it would be on a federal level, okay? And let me explain to you why this is. We live in a system of federalism where individual states can interpret their own state constitutions in any way they want, and frequently do so in a way so as to provide more protection for people under their state constitutions than you would otherwise be entitled to under the United States Constitution. So when we talk about your rights under the Fourth Amendment, I want you to think about them in terms of a floor as opposed to a ceiling. And by that I mean that the rights that you get under the Fourth Amendment are the minimum amount of rights to which you're entitled to in the United States. Your own individual state can increase the amount of protection that you get on a given search and seizure issue, and that's what happens frequently under New Jersey law. And you're going to see this happening time after time after time, okay? Now, what is the evidence in a drunk driving case that you'd be interested in seeing suppressed, okay? Well, there may be all kinds of things that will happen. Let me just give you a couple things off the top of my head. First of all, there may be evidence that will suggest what the blood alcohol concentration was of the driver of the car. This may come about as a result of a breath test that was taken by the individual following his arrest. It may come about as a result of a sample of his blood that was taken from his body following the arrest. It may come about as a result of a urine sample that was taken, although typically that's going to be more in line for drugs and other types of chemicals in his system at the time of operation, as opposed to what the BAC, blood alcohol level, was. Okay? There may be physical evidence also which will support the state's case. For example, if the police conduct a search of the car, they may find beer cans and vodka bottles and things of that nature inside of the vehicle, either in plain view or hidden inside of the vehicle. And that's evidence that is suggestive of recent consumption of alcohol. It raises the inference that the individual at some point when he was inside the vehicle was consuming alcoholic beverages. The police may also find, marijuana or drug paraphernalia, again, things that would raise an inference that it may be the defendant was either consuming controlled dangerous substances or had recently consumed them prior to the time of the operation of the vehicle. Okay? So all of these things might be subject to suppression if they are seized in violation of either the Fourth Amendment or the New Jersey State Constitution. Everybody got that? Next, it may be a situation where the defendant makes certain damaging admissions to the police, or he confesses to something to the police following his seizure. Remember, an arrest under the Fourth Amendment is the same thing as a seizure. A seizure is an arrest, and arrest is a seizure. So when you talk about arresting people, you're dealing with Fourth Amendment issues. Again, if the rights of the defendant were violated in the context of either the Fourth Amendment or the state constitution, statements that the individual made may be subject to being suppressed. Okay? And many times that's very powerful evidence of guilt, which will not be available for the state to utilize during the prosecution of the case. Now, when you're analyzing one of these cases, you have to kind of ask yourself certain preliminary questions. I want to kind of go through it with you. First of all, the police have conducted a stop in the sense that there's now some kind of a transaction going on between the defendant and the police. And you have to ask yourself, well, what's going on here? Was this actually a motor vehicle stop within the meaning of the Fourth Amendment? In other words, is the police, the traditional, the police put the lights on and they pull you over to the side of the road. Is that a constitutionally recognized transaction? Well, for your purposes, you should understand that the vast majority of the time when the police effect a motor vehicle stop, that constitutes a seizure within the meaning of the Fourth Amendment, okay? But there may be other situations where you're not dealing with a search and seizure type situation. For example, often the defendants will go up to the police and initiate the conversation with the police, or call the police over to them, or seek the police down, okay? Those situations, people are not being detained. The interaction between the police officer and the future defendant did not come about as a result of some type of seizure, but rather through some type of voluntary action. So unless the police are engaged in an activity which comes within the ambit of the Fourth Amendment, something where there's a seizure going on, there's really no constitutional issue, especially if the defendant goes up and initiates all the conversation with the police. The next thing you have to ask yourself is whether or not what the police were doing actually constituted a search. In other words, were the police actually going out and looking for evidence, or did they stumble upon evidence, or was the police engaged in some other activity that did not constitute a search and accordingly would not be a Fourth Amendment issue? And you'll see that coming up in the cases we're going to talk about. And finally, you have to ask yourself whether or not the search took place within an area that the defendant has a legitimate expectation of privacy. Remember, I told you before that you can think about the Fourth Amendment as being kind of like intended to protect the privacy of individuals. So as a result, if you don't have an expectation of privacy in the area where the police are searching, then there's really no reason for the police to act reasonably. Let me give you an example, all right? Take a situation where you're driving your car and the police pull the car over. And let's say that the reason the police pull the car over is because there is some type of equipment violation on the vehicle. Let's say a taillight is burned out. That could happen, right? Does anybody think the police have the right to stop you if you have an equipment violation? Yes? All right, nobody has any problem with that, right? Okay. So now the police pull you over and they start asking everybody's name, because there's 3 people in the car, and the police decide what they're going to do is take everyone's name and run it through the state computer system to see if there's any outstanding warrants for that individual. Okay? Make sense? So now while the police are doing that, you're just kind of waiting around for them to be done. The question is, do the police have to have some type of level of suspicion before they run your name through the computer? Let's say it's a passenger, front seat passenger of the car, Joe Smith, and they're running Joe Smith's name through the computer. Do the police have to have some type of level of suspicion to do that? When the police start searching through these databases to see if there's warrants for this individual, does that constitute a search within the meaning of the Fourth Amendment? Look at it this way, guys. If the search through that database constitutes a search within the meaning of the Fourth Amendment, in other words, that the defendant has an expectation of privacy in that type of information, then the police have to act reasonably, meaning at least they're going to have some level of suspicion before they conduct a search or have a search warrant or something of that nature. By the same token, if you don't have an expectation of privacy, the police don't have to act reasonably. They can do anything they want. So the question is, do you think you have an expectation of privacy in the records about people who have warrants? What do you think? No? How many people think no? Well, that's the right answer. There are certain areas where we just as a society are not prepared to recognize that people have a legitimate privacy expectation. Just to give you a couple of other examples, let's say prisoners, okay? Prisoners are assigned places to live. They live in cells or areas. And typically the prison officials will come in periodically and do shakedowns, look through their cells to see there's contraband weapons and things of that nature there. Do the police have to have any type of suspicion to do that? Warrant, probable cause, anything like that? Or can they just go in and do it? What do you think? What's the answer? Just go do it? Now, how do you justify that constitutionally, that they can just go into your cell, throw you out of there in the middle of the night and start searching all over the place? From a constitutional standpoint, the point you're making is exactly correct. Are we as a society prepared at this point to say that prisoners inside of a cell have an expectation of privacy? I don't think, but it's societally. Do you think we recognize a right of prisoners to have privacy in their own cells? No, and I don't think that's the right answer either. I agree with you 100%. Societally, we're not prepared to say that you have an expectation of privacy in a jail cell. Another situation that comes up in the prison context is deals with conversations that you'll have. If you're sitting in jail talking to a friend, loved one, husband, whatever it may be, do you have an expectation of privacy in your conversations with somebody in jail? Or are those subject to being monitored, recorded, and things of that nature? But is it a legitimate expectation of privacy? You think so? All right, well, the Supreme Court disagrees with you. But that's okay. I mean, you would think about it, and any time you go into a jail, you should always see the signs up there which say, your conversations can be monitored, they're subject to recording, because there's some security issues associated with it. So the Supreme Court has done a balancing and said, basically, look, we don't find that society will give an expectation of privacy to the conversations that people have inside the jail setting. All right? I just give you these as examples to kind of demonstrate this concept of expectation of privacy and when you should have it and when you shouldn't have it. Okay? Now, we're going to be talking quite a bit tonight about various levels of suspicion, and I want to discuss them with you very quickly. You're familiar with a few of them just from being here in law school. You know that, well, let me ask you the question. When you're on trial, criminal trial, what is the level of proof that the fact finder has to be satisfied by in order to have you found guilty? What do you think? Proof beyond a reasonable doubt. So the fact finder would have to prove each element of the case has been proved individually beyond a reasonable doubt. You agree? Okay. How about in the civil context where we're trying a case over an automobile accident? What's the standard of proof there?
Preponderance.
A preponderance of the evidence. And what does that mean?
Basically more than 50%.
Okay, so anything more than 50% of the credible evidence, if you sustain that burden in the civil context, you're the winner. Make sense? Now, is there an intermediate level of proof that's somewhere between proof beyond a reasonable doubt and preponderance of the evidence? Do you know what clear convincing evidence is? Well, it's actually it's important that you understand that it's hard to define if you don't look at the definition. But the definition comes through the case law, and just to paraphrase it, it's evidence that's supposed to be so clear, direct, weighty, and convincing as to enable the fact finder to come to a clear conviction without hesitancy of the precise question and issue. So theoretically, it's supposed to be somewhere between proof beyond a reasonable doubt and a preponderance of the evidence. I don't know of any court that ascribes any type of percentage of belief that you should have to it. There's a case called In Re Seaman, S-E-A-M-A-N, which in New Jersey gives the definition of that level of proof. Very important. Now, beneath this, there are much smaller levels of proof which are constitutionally significant. And the first one I want to talk to is probable cause, all right? Probable cause is been described in just for basic terms as a well-grounded suspicion that the defendant is involved in some type of criminal activity, okay? Well-grounded suspicion. It is certainly significantly less than proof beyond a reasonable doubt, but it is also considered to be more than nothing, okay? I mean, it's not a hunch. There's some level of evidence associated with it, okay? So I don't want you to get caught up in the notion that probable cause is some enormous amount of evidence, because it's not. It's relatively low on the evidence threshold, but it's more than nothing. Now, the key for all of you is to understand that probable cause is the minimum amount of evidence that's going to be necessary for the police to arrest somebody or to get a search warrant. Okay? That's what's required, probable cause. And it's significant. If you stop to think about it, there are in our country right now thousands, probably tens of thousands of people who are sitting in local county jails and have been there sometimes for months just based upon probable cause. In other words, there was sufficient probable cause to charge them with some type of offense, but they can't, and they've been arrested by the police and they're sitting in jail and they can't make bail because they don't have enough money, okay? But the level of proof that's keeping them in jail is this very low threshold of probable cause. Everybody got that? Okay. Now, beneath probable cause, we have a level called reasonable and articulable suspicion. This is less than probable cause, but again, more than nothing. A reasonable and articulable suspicion is necessary for the police to take certain actions with respect to the public. Typically, in your case, it's going to be three things. Number one, a reasonable and articulable suspicion is sufficient evidence for the police to conduct a motor vehicle stop. Okay? So if the police have a reasonable and articulable suspicion that a vehicle has violated, say, for example, a traffic law, or they have a reasonable suspicion that the individual who's operating the vehicle is unlicensed or the vehicle is unregistered, that gives the police the constitutional authority to conduct a stop of the vehicle. And remember, we talked about vehicle stops as being seizures within the meaning of the Fourth Amendment, okay? The next significance for a reasonable articulable suspicion is it will allow the police to detain individuals for investigative purposes. Typically, if the police have a reasonable and articulable suspicion that the defendant has been involved in some type of criminal activity, the police are permitted to detain that individual for a limited period of time for the purpose of either dispelling or confirming whatever their reasonable suspicion was. This is known as an investigative detention. Okay? Now, the third thing that's significant for reasonable articulable suspicion deals with searching. The police are permitted, under the circumstances where they have a reasonable articulable suspicion to believe that an individual has some type of a weapon in his possession, to conduct a limited search of that person. Typically, this is going to be a pat-down or a frisk of that individual in order to locate the weapon. So you have a situation where the police, make an observation about the individual. Maybe he has some kind of a huge bulge coming out of a pocket. He's dressed inappropriately. Maybe he's reaching into the pocket occasionally in spite of what the police are telling him during some type of detention. Under those circumstances, if the police have a reasonable articulable suspicion, they can conduct a limited search, pat the individual down for the purpose of removing any weapons from this individual's possession. Everybody got that? The minimum amount of proof that you need in order to arrest someone in the United States is probable cause. By definition, the police are detaining this individual, but they don't have probable cause. They only have a reasonable and articulable suspicion of this. So they don't have the constitutional level of proof to arrest the individual at this time. The individual is being detained. He is not under arrest. Okay? And now it's important you think about this, because once the person has been arrested, all kinds of secondary rights kick in. For example, you have all kinds of Miranda rights that apply, where the individual has to be advised about his right to remain silent and his right to counsel in the situation where there's going to be a custodial interrogation of that individual. By the same token, if he hasn't been arrested, he's just being detained, although you have the right to remain silent constitutionally, there is no obligation for the police to inform the individual that he has the right to remain silent. And by the way, that's the last thing the police want to do, is tell the person they have a right to remain silent, because the whole purpose of the detention is to either have the police confirm or dispel whatever their suspicions are. So it's really kind of counterproductive under those circumstances. All right? So those are the kind of levels of proof we're going to be talking about tonight, and it's important you understand them so that when we get into them, you're going to have some basis for understanding them. Okay, I want to jump down to justification for motor vehicle stops for a second. The landmark decision coming out of this is called Delaware versus Prowse, this 1979 decision, and basically standing for the proposition, as I just told you a moment ago, that a stop of a motor vehicle by the police under these circumstances is a seizure within the meaning of the Fourth Amendment. The minimum amount of proof that the police need in order to effect the motor vehicle stop is a reasonable and articulable suspicion, admittedly a very low level of proof. Now, let's face it, as a practical matter, when police conduct motor vehicle stops, the vast majority of the time, their level of proof is not a reasonable articulable suspicion. It's 100% certainty. Why? Because they saw the violation committed with their own eyes. You know, they saw the defendant go through the red light or speeding or whatever the violation was. They saw the taillight out, whatever it may be. That is usually going to be sufficient for the police to do it, but it's a much higher level of certainty in the police than a reasonable articulable suspicion, okay? So, although there's a very low level of proof that's required, normally you're going to have a significantly higher level of proof when the police make that stop. Now, I have a couple of cases that I want to talk to you about just briefly so you can see how these things play themselves out. The first dealing with anonymous tips. Now, typically, when the police get an anonymous tip, it's going to come in through some type of a telephone contact, and maybe usually, I would think these days, by cell phone. And the issue becomes now, is it proper for the police to effect a motor vehicle stop just based upon an anonymous tip? So, when someone calls into the police and says, listen, an individual is just kind of weaving all over the place, does that give the police a reasonable articulable suspicion to stop that individual? What do you think? What evidence do they have? Especially when you're dealing with an anonymous tip. You don't know who it is, where it came from, how recent the information is. What do you think? Do you think that the amount of corroboration you would require constitutionally should vary depending upon the type of offense that's being investigated? In other words, would you need more corroboration on an anonymous tip dealing with drug dealing as opposed to drunk driving? Let's kind of think this through, because remember, the court is implementing constitutional doctrine, but they're also, try to have some common sense about this as well. When you're dealing with an individual who's alleged to be driving intoxicated, this is a person who constitutes an ongoing danger to the community unless that person is stopped, okay? There's very little to prevent them under normal circumstances becoming involved in accidents, injuring themselves, injuring property, injuring innocent people, okay? So the need to stop these individuals now is pretty high. Is there some inherent reliability in a call that comes in anonymously? So you stop to think for a second that the police most likely will know the number of the person who's calling in. There are statutes that punish you for giving false information to the police. You have a public policy issue also, which would require some immediate action by the police, but there's not going to be a whole lot of time for the police necessarily to corroborate the information that's being given. Conversely, if you're talking about a drug situation where there's an allegation that an individual is going to be picking up drugs at the train station, okay, that's something typically it's going to require a lot more corroboration, where the police will have to follow the individual and see how much of the tip information turns out to actually be true before they can take action on stopping and searching that individual. In the drunk driving context, and this happens all the time where the police will get anonymous tips, the amount of corroboration required is very, very slight. The police will certainly want to make sure that there's some identifiers for the car, so you're stopping the right car. And it's very good if the police can see something that will corroborate what was said in the tip, some type of weaving or something of that nature. But normally, the fact that people could be tracked down and punished for giving false information is enough of a deterrent that the amount of corroboration necessary for these types of cases is dramatically reduced. Certainly when you compare it to some type of a drug or homicide investigation. Okay? I want to talk for a second also about the length of the stop. We mentioned a few moments ago about the police doing computer searches and things of that nature. Remember, these motor vehicle stops are detentions. They're not arrests. So what should the police be doing during the course of the stop? Well, they can conduct collateral type investigations, ask you questions about where you've been coming from and things of that nature while they're conducting their stop, as long as it doesn't unduly prolong the length of the stop. The issue you run into is when the stop becomes unreasonably long. What happens is it will just kind of ripen from an investigative detention and become, as a matter of law, de facto or de jure arrest. And under those circumstances, if the court views it as a de facto or de jure arrest, anything the defendant says normally is going to wind up being suppressed because, he should have been Mirandized if he was being arrested under the circumstances. So I want you to kind of keep that in the back of your mind. Okay? Now, how does Miranda play into all this stuff with respect to motor vehicle stops? That issue was discussed in the Supreme Court case of Berkmer versus McCarty back in 1984. You all know that the Miranda decision protects individuals in this context of when they are going to make statements to the police in the context of a custodial interrogation. Everybody knows that, right? So you have to have two things going. A, custody, meaning the person's under arrest, and B, interrogation. Police are going to be asking this individual questions with an eye toward getting him to provide them with information that will be incriminating. Now, what I'm talking about with the Berkmer versus McCarty situation is what happens during the course of a motor vehicle stop once the police officer has stopped the vehicle. Remember, the individual is not under arrest. He's being detained for investigative purposes, even if those purposes are just for the purpose of getting a ticket written for the individual. As a result, the police officer is under no obligation to Mirandize the individual that he has stopped. Why? Number one, the individual is not under arrest. But number two, if you think about it logically, the whole transaction that's going on the street between an individual who's been stopped by the police versus someone who's at the police station is strikingly different. I have to tell you guys a little story. When all of you were very, very small children and the OJ case was going on, part of the investigation involved the police taking OJ back to the police station. In fact, one of the detectives, Van Adders, his name, he just died the other day. They brought OJ in to question him, and during the course of his investigation, he gave a blood sample. His attorney consented to that. And he spoke to the police, I think, for no more than 15 minutes, and they let him go. All right? Now, I'm telling all of you that that's Hollywood. Let me tell you what really happens, okay? If the police take you, and if you don't believe me, you ask him. He'll tell you. If the police take you into the station and they put you in a room, you're not coming out of there until you confess. I want you to all understand that, okay? You're not leaving until you confess. Everybody got that? That's just a very simple rule of law. Forget about OJ. That's the star power that got OJ released. For the average schmo going to talk to the police, you're going to be there for a while, okay? And you're not coming out until you confess. That's the way these things go. Contrast that with the typical motor vehicle stop, where you don't have a complete police-controlled, dominating atmosphere. You have something that's done in public, usually with cars passing by and things of that nature. It doesn't have any of the attributes of the typical police interrogation type situation. So for all of those reasons, the fact that you're not under arrest, the fact that what's happening is in public normally, and the police are not in a situation where they can exercise the same level of pressure on you they can when you're in the police station, there is no requirement that the police Mirandize individuals who have been stopped for motor vehicle offenses, okay? And, it's funny to me because the people who get stopped for traffic tickets are their own worst enemies. They make the most ridiculous statements to the police, all of which are admissible against them. John, how many times have you seen they say all kinds of stupid nonsense, the police are writing it all down on the back of the ticket so they'll know when they get to court. The two funny ones I get, I had to go to a job interview. That's always a good one. And then my favorite one, the guy says, it's 104 and a 55 in the turnpike. This happened in Bordentown Court. I saw it a couple days ago. The guy had a bad tune in front of the judge. And you can visualize the scene, John, right? So the judge says, why are you going 104 miles an hour in a 65 mile an hour speed zone? The guy said, I had shit to do. Hey, it was all written down. It was an admission, I guess. All right. Now, let's assume that the police are going to conduct a stop of the car, and then they start searching the car. Okay? Everybody got it? How is it constitutionally that the police can take evidence and use it against you in a court someday? I want to go through the procedure on it so you'll all kind of be zoned in on this. Remember that all these searches are taking place in the absence of a warrant. There's not going to be a warrant normally out on the street when the vehicle's been stopped. The police utilize something that's called the plain view exception to the warrant requirement, okay? Now, I have to tell you that there's some dispute among scholars as to whether the plain view exception actually really is an exception to the warrant requirement at all, but we don't really have to reach that level here. It's important you understand what the elements of a plain view seizure are. There's three parts to it. First is that the officer has to be lawfully in the viewing area, okay? So, in the context of a motor vehicle stop, that means that the vehicle stop would have had to have been based upon a reasonable and articulable suspicion in order to put the officer lawfully in a position where he could view into the vehicle. Make sense? Or alternatively, your argument would be if the vehicle stop took place on less than a reasonable and articulable suspicion or no suspicion at all, then your argument basically is going to be he was not lawfully in the viewing area. Everybody got that? Can anybody give me an example where the police would be stopping and looking at a vehicle without a reasonable and articulable suspicion? Roadblock is exactly what I was thinking of myself. And it need not necessarily be for DWI. It could be for a variety of reasons. DWI roadblocks are not the only reason. So the vehicle being stopped there has nothing whatsoever to do with any reasonable or articulable suspicion. Okay? Your challenge, if they found some type of contraband inside the vehicle, would be that the roadblock was not legally constituted. There are procedures that the police have to follow legally in order to have a legal roadblock. It's all spelled out in the case law. And your argument is if the police don't do that, once they made their observation, they weren't lawfully in the viewing area because the police had no right to stop the vehicle in the first place. Make sense? Okay. So, lawfully in the viewing area. Number two, that the discovery of the evidence must be inadvertent, meaning that the police were not looking for it ahead of time, they just kind of saw it by accident. Okay? And number three, the police had probable cause to associate the discovery of that item with some type of violation of the law. So let's say that you pull the driver over, and you smell the odor of an alcoholic beverage on the driver's breath, and the driver is only 19 years old, and the police start shining a flashlight inside of the vehicle. They look at the vehicle, and they see beer cans inside the vehicle in the vicinity of the driver's side. Okay? Beer cans. Let's go through the steps one by one, okay? Number one, were the police lawfully in the viewing area? Well, you have to assume that they had a reasonable suspicion to stop the car under our fact pattern. Number two, did they discover the evidence inadvertently? Were they looking for beer cans in there? They shined the light in the car and took a look inside. That's what they saw. Three, do they have probable cause to associate the discovery of this item with some type of violation of the law? Well, you have a 19-year-old individual who's driving the car with an odor of an alcoholic beverage on his breath. Okay? You see these beer cans. Can you link the two of them together? Does that give you probable cause to believe that some type of violation of the law has taken place? So lawfully the viewing area, discovery of the evidence inadvertent, probable cause to associate the evidence with some type of violation of the law. Everybody got that? Okay. I want to talk about these GPS satellites for a second. This is something I just added into your materials because it came about last week with the publication of United States versus Jones from our Supreme Court. The cops went out and got a search warrant. All right? They filed an affidavit of probable cause. They took it to a judge. The judge read it over. The judge signed it and said, here's your search warrant. Okay? Now, there's only two problems. Problem number one, this was a perfectly valid, legitimate search warrant the cops have. There's only two problems. Number one, the judge says you have to install this GPS on the guy's car surreptitiously within the next 10 days. The cops wait 11 days. 1 day. Who cares, right? And number two, it has to be installed within the territorial jurisdiction of Washington, D.C. They install it in Maryland, not in Washington, D.C. But apart from that, it's a perfectly good warrant, right? So they're out of time on the installation and don't install it in the right jurisdiction. So as a practical matter, did they have a warrant or not? They had no warrant, okay? There was no warrant. You got to do what the warrant says. And these warrants go on. They have a very short time period, especially on search warrants, okay? 10 days does not mean 11. Installed in Washington, D.C. doesn't mean Maryland. Okay? So they install it, but they really don't have any judicial authority to do it. Here's the issue in the case, and it's framed out exactly what we talked about before. If he has an expectation of privacy in his car, okay, then the police have an obligation to act reasonably, meaning get a warrant. By the same token, if he doesn't have an expectation of privacy in his car, then the police can do whatever they want, right? Same issue we've talked about before tonight. That's exactly what's before the Supreme Court in this case. One of the arguments you make is, what are they doing? They're trailing this guy, when he's out in public. Well, do you have an expectation of privacy when you're out in public? When you're out there driving around and people can see you and look at the car, see where you are and things like that, do you have an legitimate expectation of privacy? What do you think? No. That seems to be the general rule, although I have a feeling that that's going to be reinterpreted by the court, especially when you're dealing with long-term following the individual around. This case actually hinged on the concept of effects. Remember we talked to you about person, papers, houses, and effects? Remember we talked about that? This was an effects case, and the Justice Scalia, writing for the majority, said that the framers of the Constitution, although they didn't realize what a car was in those days, they would recognize this type of property as being an effect, which would fall within the ambit of the Fourth Amendment, okay? A very, very surprising decision from my perspective. I was really kind of shocked to hear about it. But, that's the ruling in the case. So this is going to change police procedure when they want to use these GPS satellites. Now everybody understands that because it's an effect, they're going to have to go out and get a legitimate search warrant and execute the search warrant within the necessary time period and where territorially they're supposed to be doing it. Okay? There's a case that came out last year in New Jersey called State versus Earls, which is kind of a different take on this. What happened was the police were kind of trying to find a guy, and they called up his cell phone provider, and they wanted to find out where he was and asked the cell phone provider to give them where the pings were that were coming back from his cell phone. And the cell phone provider said, that's fine, we'll give it to you. The police got this information from them on a voluntary basis. They didn't get any type of search warrant or anything of that nature. And based upon the recovery of these pings, they were able to kind of locate where his vehicle was, and then, of course, the vehicle led the police to him. The motion to suppress is, of course, I have an expectation of privacy in the records of my telephone company related to my cell phone and where it's pinging. And our appellate division said, oh, no, you don't. This is something that you're out in public, and there is no expectation of privacy there. It was a very surprising opinion for me. I'm not sure that our United States Supreme Court, New Jersey Supreme Court would rule the same way now, especially in light of this Jones case, which just came out last week. So we'll just have to see. I know that issue is going to be back again. All right? Now, when we talk about automobile searches, perhaps the most common one that will justify the seizure of evidence is called the automobile exception, okay? And I want to talk about it a little bit because it has a long and very unhappy history in New Jersey. Let's go back to the era of 1925, okay, Boardwalk Empire time, and the landmark decision of Carroll versus the United States. In Carroll versus the United States, the Supreme Court was kind of confronted with the issue as to what is required of the police when they want to conduct a search of a motor vehicle for which they have probable cause to believe that there's some type of contraband evidence or fruits of it and instrumentalities of crime inside of the vehicle. Okay? The court recognized, especially given the communications of that era, that it's just impractical to ask the police to be able to go out and get a warrant. Motor vehicles are inherently mobile, just that's the nature of cars, and the people can just drive the car away and thwart the police investigation. Given the communications of the era, it was just unreasonable to expect that the police were going to be able to get a warrant anytime quickly. So, in order to accommodate these, the obvious need for the warrant, but by the same token, recognizing that it's impractical to get a warrant under those circumstances, the court created the automobile exception to the warrant requirement. Now, this exception says the following: when the police have probable cause to believe that there's something inside of the vehicle that is either fruits or instrumentalities of crime, contraband, evidence of crime, things of that nature, the police may conduct a search to recover that evidence, okay, in the absence of a warrant. In a sense, the police make their own probable cause determinations. Again, getting a warrant under those circumstances is just impractical. Now, the impracticality aspect of it was just one early justification for this exception. There were additional exceptions that came on as time went on, and the court had a chance over the years to reconsider this exception to the warrant requirement. One of them was that you have a lessened expectation of privacy in your vehicle when you're out there driving. Certainly less than you would expect in your own home. So when you're out there driving around, people can see you, and you're in public, and look through the glass and watch you driving and see how handsome you are. You don't have the same level of privacy expectation that you do when you go out in public as you do inside of your vehicle. So you do have an expectation of privacy, but it's diminished. And the diminution of your expectation of privacy, again, justifies the search of these vehicles. Another justification that developed in the case law for these types of searches was that vehicles are pervasively regulated, and people should have an expectation that since they're taking part in a pervasively regulated activity, once again, they have a lessened expectation of privacy when they go out and drive their cars, certainly less than what you would expect in your own home. Okay? So everybody got that so far? All right. Now, the turning point in this type of jurisprudence came about in 1996 in the decision of Pennsylvania versus LeBron. And in Pennsylvania versus LeBron, the United States Supreme Court ruled that the exception to the warrant requirement, which allows police to conduct searches under the automobile exception, is dependent upon one thing and one thing only, and that is probable cause. As long as the police have probable cause to believe that something inside of that vehicle somewhere, they can conduct a search. There is no necessity by the police to demonstrate that they were confronted with any type of exigent circumstances, any emergency type situation, in order to further justify that type of a search. The only thing that is required under federal law is probable cause, okay? Probable cause to believe something is inside of the vehicle. And by the way, I'll tell you, just while we're at it, in terms of the scope of the search is going to occur in those areas where the police have probable cause. So if the police have probable cause to believe that the contraband or whatever it is in the trunk, that's where they conduct a search. If they believe it's in the passenger compartment, they will search there. If they believe it's in the engine block, they will search there. Okay? Everybody got that so far? All right. New Jersey was confronted then, sometime after the LeBron case, I think in the year 2000, so 4 years later, with the concept of the automobile exception as how it was going to play itself out under the New Jersey Constitution, under Article 1, Paragraph 7. And in a decision written by Justice Venero, the court determined that they were going to part company with the federal government at this time and provide more protection to people under our state constitution than they would normally get under the federal constitution. The court made a determination that for purposes of the state constitution, they will continue to require that when police want to utilize the automobile exception to the warrant requirement, they demonstrate two things. Number one, probable cause, which is, of course, the minimum protection you're going to have to show. And number two, that there are exigent circumstances tending to make it impractical for the police to get a warrant under the circumstances, okay? Now, this presents an extremely grave challenge to law enforcement because it means in every case where the police want to rely upon this exception to the warrant requirement, they're going to have to demonstrate that they had both probable cause as well as exigent circumstances. And in the absence of either one of those two things, the evidence is going to wind up being suppressed, okay? Now, the difficulty from a law enforcement standpoint was that in the case, it's State versus Cook, Justice Venero really does not get into great detail about defining what exigent circumstances are. In fact, I think he says it's the type of thing that really doesn't lend itself to a neat type of definition. And he goes through and gives a couple of examples of it, but doesn't really come up with a useful definition of what exigent circumstances are. Okay? And this, as you will see as the case law develops, is going to cause enormous difficulties for everybody. Police officers need easy to understand, easily implemented rules of constitutional law to follow. And this has nothing to do with intelligence or anything of that nature. It has to do with the reality that police are working many times by themselves under enormous pressure, under dangers, many times in the middle of the night in isolated areas where they've got to make extremely important decisions that have constitutional consequences associated with it. So it has been the practice of the United States Supreme Court, at least, to, when they deal with issues associated with that the police have to know about, to come up with easy to understand, simple guidelines for them to follow. For example, in the plain view exception we talked about a few moments ago, there used to be a context that, it was a much more difficult choice for the police to understand about whether they had the right to seize the evidence under the plain view exception. So the Supreme Court changed it to make the third element probable cause to associate the item with some type of violation of the law. They did that because they felt it would be much easier for the police to understand that concept. They're used to working with making probable cause determinations all the time. And there are many, many situations that will come up where the United States Supreme Court, at least, will come up with easy to understand, readily employable definitions for the police to follow. When it comes to exigent circumstances, though, you're talking about having police follow through on a situation that's really undefinable. And the last thing you want to do is give the police, say, you got to follow a concept which we really can't define for you. It's not fair to the police, actually. It doesn't help anybody. This kind of came to a head in a case called State versus Dunlap, and I've given you the citation in your materials. Let me just tell you a little bit about the facts of Dunlap. It was a young girl, I think a teenager, had a boyfriend, and her mother was very concerned about her dating this young fellow because he turned out to be some kind of a big drug and gun dealer. So the mother kind of called the police, who came over to the house. They found some drugs in the girl's room and brought her to the police station and started pressuring her. And she had said that she had gotten it from her boyfriend, a man named Soup. That was his street name. So you guys can, you can make your own conclusions about that. So the police pressure her into setting up Soup. And they put her on the phone with him, and she makes an arrangement to meet with him at a specific time dictated to her by the police. So specific time, specific area. The police then go down and they set up basically a trap for him with kind of their version of the SWAT team. When you read the opinion, there were at least 10 police officers there waiting for Soup to arrive. At the appointed hour, Soup pulls up in his vehicle. The police are waiting for him. They spring the trap, yank him out of the car, place him under arrest, and then start searching the car. And what do they find in the car? Exactly what they were looking for. Lots of drugs and lots of guns, okay? So now we come to the motion to suppress evidence. The police want to utilize the automobile exception to the warrant requirement. Soup says, number one, I will acknowledge that the police had plenty of probable cause to search my vehicle, okay? But what were the exigent circumstances tending to excuse them from getting a warrant? The police were lying in wait for me. There was just one of me and 10 of them. So what was the big emergency? You could have had 2 of them holding me down and handcuffing me or taking me away from the scene, and that would have left 8 of them to prepare an application for a search warrant before they went into my car. Okay? And you know what? He had a good point. And the New Jersey Supreme Court suppressed the evidence, saying that notwithstanding the fact that the police had all kinds of probable cause, there were no exigent circumstances that tended to support any emergency here that would have excused the police from getting a warrant. So this was a very, very difficult case for New Jersey law enforcement because it, once again, failed to give them an easy-to-understand definition of what exigent circumstances were. That's number one. And number two, the court said 2 additional things that were very troubling. Number one, they said that we think that if there had been like 2 police officers there, it might have been a different type situation. But 10 officers, clearly there was no exigent circumstances. Okay? So that leads the police to think, okay, well, let's figure this out now. If 2 would have been exigent circumstances, but 10 is not, how about 9? How about 8? How about 7? Okay? And there's really no guidance there in terms of when exigent circumstances will be present, and it's really an undefinable thing because these are very fact-sensitive cases. To make matters worse, the court made a decision to kind of castigate the police and say, look, the police could have caught up and gotten an emergency search warrant over the telephone, okay? The problem with that is in order to get an emergency search warrant under those circumstances in those days, you had to have exigent circumstances. So, I mean, the whole thing doesn't make any sense. I mean, the reason why this is all getting suppressed in the first place is because there was no exigent circumstances. If you called up a Superior Court judge, the conversation would be, Judge, we want to get us an emergency search warrant to search this car. And the judge would say on the phone, okay, let me swear you in, because remember, all warrants have to be under oath or affirmation. And the judge would then ask, what's your probable cause? And the officer would describe the probable cause. And then the judge would say, okay, what's your exigent circumstances to get an emergency telephonic search warrant? And the officer would say, well, we don't have any emergency circumstances. That's why we're calling you. At which point, the judge should rightfully hang up. And the Supreme Court actually says that twice in the opinion, something that just doesn't make any sense. It's totally illogical. There were additional attempts following this Dunlap case, because the Supreme Court knew they were in trouble, to try to define what exigent circumstances were for the police. And I have to tell you that despite their best efforts to define it, it just made it worse. They were dealing with something that's just not capable of being defined in an easy way for the police to understand. All of this kind of finally came to a head in the publication of the landmark decision of State of New Jersey versus Peña-Flores, where the court finally tackled this problem and changed it in a way that the police could deal with it now finally. Now, I told you a moment ago that there is a procedure, or there was at the time of the Dunlap case, where the police could call up and get an emergency telephonic search warrant, okay? 2 things were required under the former law. Number 1, probable cause, and number 2, exigent circumstances. In the Peña-Flores case, the New Jersey Supreme Court says we're going to change the procedure from now on. The police can call up and get an emergency search warrant over the telephone. It's not a problem at all. And in order for them to get the search warrant, all they need to demonstrate is probable cause. There's no longer going to be any necessity for the police to demonstrate exigent circumstances when they're applying for a search warrant. Okay? So, in a sense, let's face it, it wouldn't be proper for the Supreme Court to be changing, the law. I mean, once they've interpreted the Constitution, they're pretty kind of locked in as to what the Constitution means. But they could change the court rules all the time, all right? So that's what this was. It was a change in the court rules, which now allows police in New Jersey to get a search warrant just based upon probable cause and get it over the telephone. So, theoretically, if the police make a stop and they want to search your car, they have probable cause, all they have to do is contact the emergency judge, and the judge, if he's satisfied there is probable cause, will give them the authority of a search warrant to conduct the search of the vehicle within the scope that is authorized under the warrant, okay? An enormously big change in New Jersey law. Conversely, the police still have the option today of conducting searches without a warrant based upon probable cause and exigent circumstances. And in the Peña-Flores case, the Supreme Court went through and gave some kind of concrete examples to the police as to what they would consider factors in deciding whether or not there's exigent circumstances in a given case. Now, the case was published in 2009, and in the intervening years, I'm not satisfied at all that the police have kind of gotten the message. Johnny, have you had a telephonic search warrant case yet? Can you go on mic for a second? I want to ask you a question. What do you attribute the fact that police are not taking advantage of the telephonic search warrant procedure first, in the sense that they're buying themselves a lawsuit when they conduct a search without the warrant?
This was just argued in the cases that are now where they're reconsidering Peña-Flores.
Right.
That the number of consent searches has gone through the roof.
Right.
Why aren't they using a warrant procedure? Well, because I think basically they're lazy.
Okay.
And it creates too much of a problem for them to try and get a judge on the phone, even though there are duty judges throughout all of the counties. But I think I think it's unfamiliar with them. There's really no guidelines in place for them. that I'm aware of. And it's a matter of expediency.
Well, it seems to me if I were advising them as county prosecutor, I would say you should always get a warrant, because why get involved in a situation where you know you're going to be put on a situation where you've got to defend yourself in a warrantless search context, you know?
How many times have you seen the appellate division say we are baffled by the attitude that they would rather fight than switch? You know, they just find a different way to do it. The consent forms are all, at least the dozen or so that I've looked at, are all screwed up.
Right.
And I just think that it's much more expedient for them to browbeat somebody into letting them consent to search their car.
All right. Well, it's certainly faster. That's one way of doing
Much
it. Okay. Thank you, John. We're going to talk for a second then about what the future holds here. I don't know whether or not Peña Flores is going to continue to be good law in New Jersey or not. At some point, it's going to be reconsidered by our Supreme Court. There's a different makeup of the court. Yeah, it was, and there's a different makeup of the court now. Do you think that at least one of the justices told me privately, and he wasn't hedging his bets, but his argument was, what is to prevent the justices from saying we're going to just adopt the federal standard and eliminate the requirement of exigent circumstances on automobile searches? You have two constitutional provisions identically written, okay, but interpreted totally differently by two different bodies, by the United States Supreme Court and the New Jersey Supreme Court. Our court has ruled already, at least in the year 2000, the Cook case, by saying our state constitution means X. It means these two things. So under what basis do they go back and say, oh, it doesn't mean that anymore? I mean, if you have a constitution that you can change willy-nilly just by virtue of the court that's there, you know, what foundation is that for government?
Actually, I'm much more impressed by the United States Supreme Court adherence to the rule of stare decisis than I am by the New Jersey Supreme Court and their adherence to that rule. I think that they have judicially legislated from the bench many, many times. I think that the warrant requirement under Peña Flores has become unwieldy, unworkable for them, and as a matter of expediency, I think the smart money is betting that they're going to move back to the federal standard.
But you see what I'm saying in terms of an institutional problem? Justice Scalia, and you and I have talked about this in the context of Crawford cases, Justice Scalia is a strict constructionist, all right? He's looking to what the intention of the framers was, and that's the way the Constitution should be interpreted, okay? You can't change the Constitution every 5 minutes with the shifting political winds or whatever's expedient, and I think that this would be an example of doing that.
Well, there's 7. Where do you think they line up on the New Jersey Supreme Court?
I don't know, because I've never really thought that this was a possibility, because I think it's just so anathema to constitutional doctrine.
And it may be that they don't wholly go to the federal standard, doing away with exigent circumstances.
Right.
It may be that there's some modification in there.
Look at it this way. I mean, this was decided what year? 2000? However many years ago that was. It's getting a little bit old. Let's talk about one of your favorite cases for a second, Gideon versus Wainwright, okay? Now, Gideon versus Wainwright, when it was decided, overruled a previous interpretation of the 14th Amendment, which had only been 20 years old at that point. So I guess, you know, when it kind of, who's to say that they can't reinterpret the provision of the Constitution? I guess they do that kind of stuff all the time, you know, now that I think
Look
about it.
what they did with Crawford. That was a paradigm shift in the rule. It changed. It threw out 35 years worth of evidence law in favor of the right to confront certain witnesses under certain circumstances.
It'll be interesting to see what they do here. I don't. What's your prediction, by the way?
I think they move away from Peña Flores,
and
whether they adopt the federal standard or whether they just fine tune what they've got out there. What I'm hearing is that they're very uncomfortable with the number of consent searches.
Okay.
And quite frankly, I think that most of those are coerced anyway.
Well, let's talk about consent for a minute. Consent is recognized as another exception to the warrant requirement. And I have a section here starting with the, you see it on the third page, guys? Consent searches. This is another one of those instances where the state of New Jersey provides you enhanced protection under our state constitution more than you would get under the federal constitution. Now, there are consent searches generally, and then there are consent searches that take place in the automobile context. So we should kind of talk about them for a second. The general rule in consent searches, either federally or in the state, is that they have to be voluntary and knowing. In other words, you have to voluntarily and knowingly relinquish your right of privacy and allow the police to conduct the search of whatever area they want to search, okay? That's the same either in a state level or federal level, okay? However, the distinction comes down as follows, that you have a right to refuse to give your consent. And in the federal system, although you have a right to refuse to give consent, which is perfectly fine, there is no obligation for whatever federal officials are conducting the consent search to inform you of that or to prove it at any type of a hearing. In New Jersey, in order to provide extra protection to people, there is a requirement that the government, during the course of a motion to suppress evidence, demonstrate that the person who was giving his consent knew not only that he had the right to, or that the consent had to be given voluntarily and knowingly, but also they have to demonstrate that he knew he had the right to refuse to give consent, okay? Now, how do you prove that? Well, typically is one of two ways. Either you will confirm the person knows this through some type of oral communication with that individual, or you'll actually tell the individual that he has the right to refuse, either say it to him verbally, or giving him or her a piece of paper which is written on, having him sign it. So that's kind of evidence that this individual had knowledge that he could refuse to give his consent to the search, okay? So in that sense, you get additional protection. But when you carry it over to the motor vehicle context, there's even more protection. And this is something that's highly political in our state. There was an era during which the police, during the war on drugs, conducted an enormous amount of motor vehicle stops and conducted consent searches, especially along the New Jersey Turnpike. The evidence seemed to suggest that many of these stops were done without any proper articulable suspicion, but more importantly, that the searches were conducted without getting the full consent of the individuals who had been stopped. The idea being that people were being stopped and subject to search, not based upon objective evidence, but other criteria, though the allegation specifically being racial profiling, okay? So out of this came the case of State versus Carty. Carty adding an additional layer of protection to people in New Jersey, which is as follows. That in the automobile context, if the police want to conduct a search of a vehicle based upon the consent of that person, in order for the police to even ask for the consent, before they can ask for the consent, they have to have a reasonable and articulable suspicion that there's some type of contraband, criminal evidence, those types of things inside of the vehicle. Now, if you think about it, it kind of makes sense because, again, if they had probable cause, they could search the vehicle under the automobile exception. They have less than probable cause. As long as it's to the level of a reasonable suspicion, they are now permitted to ask for consent to search the vehicle. But in the motor vehicle context, in the absence of a reasonable articulable suspicion, the police under New Jersey law are not allowed to ask for consent to search the motor vehicle. Now, you've got to keep this in context. First of all, what I'm talking about would only apply in New Jersey. This is not the federal standard at all. Number two, only applies in the context of searches of motor vehicles. It wouldn't apply in the search, say, for example, of a house. You don't need a reasonable and articulable suspicion to believe there's contraband inside of a house in order to ask for consent to search the house. This is something that was done, pinpointed to address a specific problem, that dealing with racial profiling and searches that took place on a consent basis on the Turnpike, okay? Now, of course, this procedure is not limited to the Turnpike. It's for everywhere in the state. But I want you to keep that in the back of your mind, that that's really what the state of the consent is now, okay? So, what are the challenges to the evidence that's recovered as a result of a search based on consent? Well, number one, that the consent was not freely, voluntarily, and knowingly given, okay? Rather, it was the product of some type of force or coercion in the individual, or that the individual was not informed, well, not informed, but just was not aware of his right to refuse to give the consent, or that the police did not have a reasonable and articulable suspicion to conduct the search in the first place, or actually to ask for consent to conduct the search in the first place. Okay? Everybody see those things? And every one of those things is in play these days when you're dealing with a consent search. Now, I want to kind of go back for a second and talk about some additional exceptions that are, what's the word? Not as relevant anymore as they used to be. And one in particular is search incident to an arrest, okay? Now, the idea that police can conduct searches incident to an arrest of an individual was expounded or created by the Supreme Court in Schmel versus California back in 1969. And in the Schmel case, the court created this rule of law that permits police to conduct a search of an individual when they've arrested that person. And typically there's three justifications for the search. Number one, to allow the police to recover weapons that could be used against them. Number two, to recover implements of escape, things that the defendant could use later on to try to get out of custody. And number three, to recover evidence, okay, evidence that might be in the person's possession at the time of the arrest, which he or she might later try to discard, unless it were recovered by the police. This is not a search that's based upon probable cause. It's not based upon anything. And I guess the reason it's not based upon probable cause is because the purposes of the search are kind of public policy searches, public policy reasons. But number two, the fact the defendant has been arrested, there's obviously probable cause to arrest him for something. It might be on the basis of a bench warrant. It might be on the basis of an arrest warrant that was issued by some type of a court. It might be on the basis of some criminal activity that took place in the view of the police, and they saw it happen, and that gave them the justification for implementing their powers to arrest that individual, and then conducting a search incident to the arrest. Okay, but there is no probable cause associated with this type of search. It's just the police will do it as a matter of routine every time they arrest the individual, and of course, anything they find in possession. The person can be independently prosecuted for that. Can be used as evidence against him. Nothing good can come of it, basically, from the perspective of the defendant. Typically, the police will conduct an initial search of the person at the scene of the arrest, and then thereafter conduct a much more formal search. Dean, I'm thinking about that thing we have up on our website where the defendant gets stopped by the cops for robbing a bank, and they throw him over the back of the car. And he's got a piece of paper that the cops take out of his pocket, put in front of him, and he starts eating the paper. Do you remember that? Yeah, I do. Remember that? That's he was eating the note, that he gave into the police. Didn't realize it was evidence. It's a good thing that he ate it fast, because the police would have grabbed that and used it as evidence against him. Okay, so far so good? All right. So not a whole lot going on here. This is the scope of this search typically is going to be the wingspan area of the defendant. In other words, the area that he could the grabbable area. So it's his person, clothing that he might be carrying, and anything in the area where he could reach out and grab some type of a weapon. Okay? Everybody got that? All right. Now let's transfer this over to the automobile situation. And this came up in the context of a case called New York versus Belton in 1981, where the Supreme Court took the logic behind the Schmel versus California and applied it in the motor vehicle context. The rule of law basically was that when an occupant of a motor vehicle gets arrested, the police can conduct a search of the interior of the vehicle, again for the limited purpose of recovering weapons, implements of escape, and evidence. Okay? Really, that was just as simple as it was. And I will tell you that for years and years and years after the publication of this Belton case, that's exactly what the police did. Anytime they stopped the vehicle and arrested one of the occupants of it, they would go in and toss the vehicle and recover whatever they could. Now, let's face it, there's some logic issues associated with this. You take a typical situation with the police, let's say it's a drunk driving case, okay? The police pull the vehicle over, there's a single person inside of it. The police detect the odor of an alcoholic beverage on the breath of the individual who's the operator, yank that person out of the car, have him perform psychophysical evaluations. They develop probable cause to believe that he's been operating under the influence of alcohol. Statistically, what is the statistical probability that someone who's been handcuffed and sitting in the back of a police car is going to be able to go back to his vehicle and grab a weapon and use it against the police? All right. 0, right? So what is the justification then for the police being able to search a vehicle for which there is no possibility that anybody's going to go in and grab a weapon, destroy evidence, or anything else? What's the justification for that logically? There isn't any. It's zero, okay? So, I mean, when you start to think about it, this was a very, very happy tool for the police to use. And I'm telling you, over the years that the Belton decision was around, there are many, many unhappy people who wound up in jail and had a lot of evidence against them seized by the police, incident to their arrest, not from the search of their person necessarily, but from the search of all the stuff they had hidden inside of the vehicle, okay? Now, as you can imagine, because of this issue about people being handcuffed in the back of police cars, and there really being no justification for the search of the vehicle for implements of escape, weapons, or recovering evidence, the Belton rule was subject to an enormous amount of criticism by legal scholars, okay, around the country. In New Jersey, the facade started to crack in a case called State versus Pierce in 1994, where the Supreme Court really started kind of having grave misgivings about the utility of this rule, the fairness of this rule, and whether or not it should continue to be part of the fabric of New Jersey law. The Supreme Court echoing similar concerns expressed by the Appellate Division in the same case. There were some procedural changes that came out of the Pierce case in 1994, but nothing that really would make the rule, what's the right word, inactive in New Jersey, okay? That did not happen for a while. In fact, the while ended in 2006, where the Appellate Division first and later our Supreme Court made a determination in a case called State versus GSCLE that the search incident to an arrest exception, as authorized under the Belton case, was no longer going to be part of the fabric of New Jersey law, okay? That our state constitution will not countenance this type of activity by the police for all the reasons that we've talked about. This is just something that wasn't popular in the first place, but it was not going to be permitted any longer in New Jersey, okay? Now, this was a real problem for the police. I mean, when you stop to think about it, you may have a situation, for example, that, I gave the example of one person being in the car and being locked up. That's perfectly fine. But what happens when you have 3 and 4 people, that are inside of the vehicle? You have one driver and 3 passengers. What's to say, previously when they arrested an occupant, the police could go in and search the vehicle to find out if there's any weapons there. With no basis for searching the vehicle based on incident to an arrest, how can the police assure themselves that they're not going to be subject to any type of attack by other individuals who have weapons hidden inside of the vehicle? So this was not a particularly popular decision among the police back in 2006. And I have to tell you, it was just one of those things where the police had to adapt and overcome and find different ways of doing their job without utilizing the search incident to an arrest exception to the warrant requirement to search the vehicles. It's interesting that the case went before the United States Supreme Court again in, I think I have it cited for you, in Arizona versus Gant back in 2009. And at that point, the United States Supreme Court finally caught up to the New Jersey Supreme Court and backed down significantly on the Belton rule. And of course, as happens sometimes, it was really an amazing decision. You remember this case, Johnny? They actually blamed everybody else except them. They said, we never intended that the police would conduct searches every time they arrested somebody. Of course, this is what's been happening every minute since 1981. So the bottom line is that the Belton decision, for all intents and purposes, is no longer good law in the United States. The Supreme Court of the United States having backed down from it. Now, the Gant case required police agencies locally and federally to make significant changes in the procedures they utilize when they conduct searches after an individual has been arrested. New Jersey police have already adapted to this change, and they have their own procedures in place now to take care of it. But I just want everybody to kind of be aware of that. Now, I want to talk about the issues about what the police can and cannot do to ensure their own safety during the course of a motor vehicle stop. Okay? Very important concept. And, the courts are very, very supportive of the issue of police safety, and they recognize that this is dangerous work for the police. Many police are injured, many killed every year as a result of interactions with motorists that they've stopped. So recognizing the danger associated with it, the courts want to kind of cut a balance between the protections ensured under the Constitution and the practical aspects of police work, all right? Now, we talked earlier on about this concept of reasonable and articulable suspicion. And I told you, generally speaking, there are three things that are going to flow from it, one of which is the authority of the police to conduct a pat-down or a frisk of an individual if they have a reasonable and articulable suspicion to believe that person is possessed of some type of weapon. The same rule of law applies to police in the motor vehicle context. Coming from the United States Supreme Court, the case is Michigan versus Long, standing for the proposition that if the police have a reasonable and articulable suspicion to believe that there is some type of a weapon inside of the vehicle, something that could constitute a danger to them, the police have the authority to go in and to recover that weapon, okay? Once again, just like in the pat-down or frisk situation, this is a limited search of the motor vehicle, limited in the context of their intention is to recover weapons. It's not a search for evidence. It's a search for weapons. Search for weapons. It's not a search for evidence, okay? By the same token, if during the course of that search they discover in plain view some type of contraband or evidence, things of that nature, they are entitled to seize that evidence. Everybody got that? It's a plain view discovery. What puts the officer lawfully in the viewing area when he's snooping around under the seats looking for firearms? It would be the reasonable and articulable suspicion that there's some type of a weapon in the car, okay? That's what puts the officer lawfully in the viewing area. Is he looking for a pound of marijuana or an 8-ball of cocaine? No, he's looking for weapons. So his discovery of the cocaine is inadvertent. And finally, does he have probable cause to associate the cocaine with some violation of the law? And of course he does, okay? So keep that in the back of your mind. Now I want to talk about scope for a second. The scope of this search is limited in the sense that the scope takes place inside the passenger compartment of the vehicle, areas that someone inside the vehicle could reach and grab something. So grabbable areas inside of the vehicle together with unlocked containers. So, glove compartments. What do they call those things in the middle of the car that you can open up? Hatch. What do they call those? Console things. It might be containers, unlocked luggage, cases, and things like that again, unlocked because it's readily accessible that way. Often I'll get questions from police about hatchback cars, and I don't know of any law on hatchbacks, but I will tell you that if someone could reasonably grab in the back and get a weapon out of it, I suspect that a court would sustain a search by the police in that area of the car, since this is an area that you could readily grab things from. By contrast, areas which are not readily accessible to the driver or passengers is usually going to be off limits for this type of search. That's going to be the trunk, engine, that type of thing, okay? In particular, the trunk, though, especially if the trunk's locked, because it's not likely that someone's going to be able to readily access a weapon that's hidden in the trunk. So far, so good? Everybody understand? Okay. So the level of suspicion, reasonable and articulable suspicion, searching for the weapons. How about failure to cooperate, antagonistic attitude by them? The police are familiar that the person has a history of violence, or they call up and they know the person has a arrest record which shows violence, or the officer knows personally that the person has acted violently. Okay? I mean, these are all things that kind of go into the mix. It could be, too, that the reason for the motor vehicle stop, you're stopping the vehicle to investigate a crime involving violence. It could be a robbery. It could be some type of sexual assault or something of that nature, where a weapon was used or there's suspicion that a weapon was used. I'm not trying to nail in anything in particular. What I'm trying to tell you is that these are all factors that go into the determination as to whether or not there's a reasonable and articulable suspicion to believe there's weapons inside of the vehicle. Remember, we're talking about a very slight amount of evidence, but it's got to be more than nothing. Okay? Everybody got that? Now, along with the line of officer safety, we have to deal with the authority of police officers over individuals who are in the motor vehicle at the time of the stop. Okay? One of the exceptions that comes about in Fourth Amendment jurisprudence with respect to motor vehicle stops, where you don't need any level of suspicion at all, deals with the relationship between the operators of motor vehicles and the police. And the bottom line is this: whether or not the defendant, the driver, stays in the vehicle or doesn't stay in the vehicle is strictly a matter of police discretion, okay? So if the police want to leave him in the vehicle while they're doing their job, that's perfectly fine. Contrast that, though, if they want to order him out of the vehicle, they have the right to do that as well. And if the police want to order the driver out of the vehicle, there is no level of articulated suspicion that is necessary. It is strictly a police call, all right? The court deferring to the police out on the street to make the decision of what's best for them, given the particular facts of the case, the location, time of day, and all the other myriad circumstances that go into police-citizens encounters in the motor vehicle context. All right? It is strictly a police officer's call. Now, what does this have to do with the Fourth Amendment? The answer is everything. Why? It's not the fact that the defendant is inside the car or outside the car that makes a difference. What happens is when the defendant gets out of the car, it opens up new vistas to the police officer where he's going to be able to make observations inside the vehicle that he was not able to see previously. So the mere fact that the door is open and the individual steps out of the vehicle now will reveal the seat, the floor, the console, and other areas that were previously not readily visible to the officer. Okay? So it's when he gets out of the car that the officer sees the butt of a handgun hidden between the seats, or the marijuana hidden between the seats, or the butt of the shotgun, or whatever it may be. All this stuff now is in plain view by virtue of the individual leaving the car. Under those circumstances, then, the police will be able to seize whatever the contraband is in plain view. But this is the key that you have to understand. The fact is that there is no required suspicion for the individual to leave the car. He either leaves or stays, depending on what the police order. But when he leaves the car, that very frequently gives the officer an additional opportunity to make an observation inside the vehicle. Now, I've been talking about drivers at this point, okay? The case related to drivers, Pennsylvania versus Mims, was decided in 1977. And although it was kind of implied inside of the opinion, there was really never any firm decision by the United States Supreme Court about what the rule was with respect to passengers. The rule that applies to drivers also applies to passengers. So if the police want to order a passenger out of the vehicle, they have the right to do that. They don't need any articulable level of suspicion to order the individual out. Okay, now remember, I'm talking about the United States Supreme Court here. Okay, not talking about New Jersey at all, just U.S. Supreme Court. So for your purposes, same rule of law applies both to passengers and drivers. It's the officer's call. Everybody got it? That's not the law in New Jersey. In New Jersey, again, as so often happens in these situations, there is more protection afforded you under our state constitution than you get under the United States Constitution. In New Jersey, the way things work out is as follows. Our court follows the United States Supreme Court with respect to drivers, okay? There is no distinction. It's an officer call. No problem there. The issue comes up with respect to passengers. And in New Jersey, for the police to order a passenger out of the vehicle, the police have to have, and I want to choose my words here very carefully, a heightened level of concern for their own safety, okay? Heightened level of concern. If the police have that, they can order the passenger out of the vehicle. It's a slight amount of protection, but markedly different than when you get under the United States Constitution, which requires no level of articulable suspicion at all. It's an officer call. Here in New Jersey, the court requires that there be some level of concern on behalf of the officer for his own safety. Now, how much does that have to be? Well, the court makes it clear that this level of suspicion is less than a reasonable and articulable suspicion. So you're talking about an extremely small amount of proof. A hunch is, I think, technically based on nothing. It's just based on gut reactions. I mean, there has to be something articulable, but what would that be? Okay, the guy wasn't cooperating. He's nodding off. He wouldn't listen to me, that type of stuff. These are the types of things where, you're knocking on the window and the guy's not paying attention to you. that's probably going to be enough under most circumstances for the police to order that individual out of the car. And of course, it's when they get out of the car that's when the problems begin, because then the police can see the drugs, the guns, or whatever it is inside of the vehicle that in plain view that they couldn't see before. So again, it has to be more than nothing, but a very, very small amount. If the passenger has committed a motor vehicle infraction himself, the passenger can be ordered out of the car without any further suspicion. Now, under what circumstances could a passenger commit a motor vehicle offense? Can you guys think of one? What do you think? What's that? Littering. I like that. I've never even thought about that. Okay, littering, that's fine. In other words, allowing an intoxicated driver to operate a motor vehicle. All right. Any others? What's the number one offense that passengers are going to commit in New Jersey or anywhere else? What is it? Seatbelt, of course. Of course. That's what's going to come up most of the time. So the police officer will look in, see the passenger's not in a seatbelt, and then order him out of the car. But I agree with all of you. These are other offenses that passengers can commit, allowing an individual to operate while intoxicated, allowing an individual to operate an insured motor vehicle. Let's see, what else? You may be in a situation where the driver of the vehicle is a probationary driver and requires a supervising driver to be in the car while he's operating. And under those circumstances, if the driver commits an offense, the same offense is attributable to the passenger, so he can be ordered out of the car. But these are kind of hybrid situations. The main one that's going to come up that will serve as a justification to have this individual leave the vehicle without any further ado, so to speak, is going to be the seatbelt violation. Just as a practical matter, that's what's going to come up the most, okay? Now, once in a while, the cops will walk up to the car and open the door and yank it open and tell the guy to get out, all right, without any warning ahead of time. And, of course, when this happens, police opens the door, and he will look in and now be in a position to make observations, see things that he hadn't seen previously in plain view, sees those things as evidence. Question: under what circumstances can a police officer just yank open, let's say for the sake of argument, a passenger door of a vehicle, okay, without any warning to those individuals? I mean, all kinds of private things are going on inside of a vehicle. The police are coming up and yanking the door open. Anybody have any problem with that, with the police coming up and just opening up the door without any type of suspicion? There's no difficulty with the police officer if opening the passenger door, assuming that the passenger was going to have to get out of the car anyway, because either there was a heightened concern by the officer or the passenger committed an independent violation of the law. Since he's getting out of the car anyway, it doesn't make any difference whether or not the officer opens his door. Now, although the court doesn't discuss it, I think they would rule the same way with respect to the driver, that the driver's going to get out of the car one way or the other, so it's really no big deal if the officer goes over and opens his door for him. Two more things I want to talk about, guys. We mentioned roadblocks before. You should understand that roadblocks for the purposes of detecting drunk drivers is constitutionally permitted, both in New Jersey and in under the United States Constitution, although New Jersey was first by 5 years and interpreted totally under the state constitution. Some motor vehicles that are subject to pervasive regulations, like these trucks, 18-wheeler trucks and things of that nature, the police are allowed to conduct searches of these vehicles under an exception to the warrant requirement called the administrative search exception. And the reason for that is because the police can they undertake these searches on people involved in an industry that's pervasively regulated. There's nothing more regulated than trucking, believe me when I tell you. And the search is done under the authority of regulations, which, in a sense, are a substitute for a search warrant. They circumscribe the authority of where the search can take place, under what circumstances it can take place, what the scope of the search is, what they're looking for, where they can go in the vehicle, where they can't go in the vehicle. So these regulations are basically a substitute for the warrant. That's why the courts will allow these searches to take place as an exception to the warrant requirement, as opposed to making the police go through and get a search warrant.